ሰላም ጤና ይስጥልን ውድ የኢትዮጵያ ስኩል ኦፍ ላው ቲዩብ ቤተሰቦቻችን እንደምን ቆያችሁልን? በክሪሚናል ፕሮሲጀር ክላስ ተገናኝተናል። አብራችሁ ቆዩ።
Whenever police believes that the offense has been committed by a certain person, the first thing that the police will do is requesting that person to appeal before him. Requesting that person to appeal before him. So if I am police, an investigating police officer, for example, an accusation has been made to me. Okay? So the accuser might have given me every relevant information related to the offense. I will record everything. Then I will investigate it. I mean, I'm a police, and I know police technique. So I will analyze the evidence, the information I received. Then I may say, oh, Mr. X should be investigated, or Mr. X should come, because the evidence directs me to RBC. So he might have committed the offense. I may reasonably believe that the offense is committed by Mr. X. So I should get Mr. X. Mr. X should come, and he has to be under the control of the police. So making a person under the control of the police is known as arrest. Arrest is nothing but making a person who is suspected to have committed an offense under the control of the police. So it shouldn't necessarily be made by force. Okay, so what matters is the person has become under the control of the police. That is what we call arrest. So the person has to be arrested. Person has to be arrested. Okay? So that arresting may be made by a summons. Under Article 25, we have seen that police will issue to Mr. X to appear before him. That is what we call summons. That is what we call summons. So summons is a document issued by police requesting the person to appear before him, or to appear before her, or the police, to appear before the police. That is summons. Okay? So summons, people may be law-abiding citizens, that person may respect that request and may appeal. He may appeal. So in that case we say he is arrested. Okay? He is arrested. So whenever a document, summons is given to him, then he submits, then he is arrested, we will say. But he may decline, he may reject it. So in such cases, police has to find out as a mechanism. Police cannot use force in such cases, mind you. If someone is rejected, police cannot use force. Okay, then police has to get arrest warrant. Arrest warrant. So arrest warrant is something issued by court. So police has to apply to the court and he has to get arrest warrant. In that cases, the suspect cannot, decline. Okay, the suspect cannot decline. Police can use reasonable force. So we have seen Article 26, Article 25. We have considered that where the investigating police officer has reason to believe that a person has committed an offense, he may, by reason summons, require such person to appear before him. So the term may indicate that sometimes summons may not be necessary. Sometimes summons may not be necessary. For example, the offense is a flagrant offense, or like dangerous vagrancy proclamation. There are some kinds of offenses which do not require the police to issue summons. So if the offense is a flagrant offense, for example, from that moment on time, that person will be arrested. That person will be arrested if it is possible to get that person. As we said, flagrancy doesn't necessarily mean that, flagrancy doesn't necessarily mean that the person has become under the control. He might have escaped, but still the name of that offense is flagrant offense. But in some cases, he may be caught red-handed. He may be caught red-handed. So in such cases, there is no need of processing summons, warrants, that is not necessary. So that's why it says may, Article 25. So, but if that person is not arrested on, like if the offense is not flagrant offense, then police needs summons. Police needs summons. So by using summons, he may be arrested. Otherwise, if he declines, then arrest warrant is necessary. So we have considered Article 25 and 26. Okay. So the investigating police officer, okay, if the person refuses to come after the summons, if the person refuses to come after the summons, then police has to get an arrest warrant. Then what is arrest warrant? And we will consider today in detail. Last time we have touched upon it. So we said generally that arrest with warrant is the rule, arrest without warrant is the exception. So in principle, arrest cannot be made. Arrest cannot be made without warrant. Arrest cannot be made without warrant. Arrest with warrant is the rule. Arrest without warrant is the exception. Arrest without warrant is the exception. So, Article 49, save as is otherwise expressly provided. Article 49, save as is otherwise expressly provided, no person may be arrested unless a warrant is issued, and no person may be detained in custody except on an order by the court. An arrest without warrant may only be made on the conditions laid down in this section, it says. So, no person can be arrested, okay, without a warrant, save as is otherwise expressly provided, it says. Okay? And the second statement, no person may be detained in custody except on an order by the court, it says. You don't have to be confused, we will see this thing right today. Okay, custody, detention. Detention, what does it mean? So no person may be detained, no person may be detained except an order of the court. And it also says, no, save as is otherwise provided, no person may be arrested without warrant, it says. And no person may be detained without an order of the court. Okay? So, let's first consider detention. It will be clearer today as we go deep into the sections. But for the time being, at least you should know that arrest with warrant is a rule, arrest without warrant is an exception. It means, as a rule, arrest has to be made with a warrant. And exceptionally, arrest without warrant is possible. So, what are the exceptions? What are the exceptions? Okay? So one exception that you can easily remember is whenever the offense is, what kind of offense? Flagrant offense, you remember it. So whenever the offense is a flagrant offense, there is no need of getting an arrest warrant. Okay? So the police can immediately arrest, making the person under control. Okay? But the question that comes to your mind in this case is, that should come to your mind. I mean, if the offense is a flagrant offense, and if the person still resists, what can the police do? What can the police do? We will raise it, I think, whenever we consider the coming provisions. Okay, so Article 50, very quickly read Article 50. We don't have time, by the way, you have to be very alert. And you have to be very active. Article 50, arrest without warrant in flagrant cases. Any private person or member of the police, mind you, any private person or member of the police, like I and you, private person, or member of the police, may arrest without warrant a person who has committed a flagrant offense as defined in Articles 19 and 20 of this code, where the offense is punishable with simple imprisonment for not less than 3 months. There is a prescription, I mean there is a condition. Simple imprisonment for not less than 3 months. That means it has to entail more than 3 months simple imprisonment. So the society, whenever a person is, red-handed, in many cases, people, grab that person and take him to the police. And he, that person receives anything, isn't he? He doesn't have any guarantee, and nobody will, object that that person shouldn't be beaten. So if you are red-handed, it is very difficult. It is very difficult. Or people, all people will beat you, and as if it is, allowed by law. People do whatever they like with that person. So is it something in line with the law? Does the law, tolerate that conduct? Okay. So any private person or member of the police may arrest without warrant a person who has committed a flagrant offence as defined in Articles 19 and 20 of this code, where the offence is punishable with simple imprisonment for not less than 3 months. So it has to entail simple imprisonment of greater than 3 months, or not less than 3 months. It has to entail simple imprisonment. By the way, simple imprisonment. What simple imprisonment means? An offence that entails from how many months or days? Simple imprisonment. What do we mean by simple imprisonment? From 10 days to 3 years. And in some cases, it may extend up to 5 years. It may extend up to 5 years. Simple imprisonment. Whereas rigorous imprisonment is an offense that entails from 1 year up to 25 years and sometimes for life. Okay? That is simple imprisonment. Whenever you read simple imprisonment, you have to remember it's a kind of offense that entails from 10 days to 3 years, and in some cases it may go up to 5 years. So the offense should entail a minimum of 3 months. This means it has to entail more than 3 months. So in such cases, private persons or members of the police can arrest that person. What does it mean, by the way? It means if the offense entails less than 3 months simple imprisonment, even though it is flagrant, you cannot arrest. Is it feasible? Do you think that the public will obey this order? And after all, is it practical, by the way, to set? Is it practical to set this 3 months? What does it mean? Is it feasible? Why not, as long as it is flagrant, why not the public or member of the police be allowed to arrest that person without a warrant? Why not? Except crimes punishable upon complaints. That is totally justifiable. But in relation to other kinds of offenses, why such restriction? What is the logic behind this? Now, flagrant offense ሲፈጸም አይታችሁ ሌባው ትይዙት ብላችሁ ስንት ከ3 ወር በላይ መሆን አለበት ለካ 3 ወር ለካ መሆን አለበት 3 ወር ይሞላል ላይ እስቲ ክሪሚናል ኮድ ላይ ለጥሩ ነው ሰውየው እኮ እዛ ጉድ እየሰራ ነው እና አሪጎን ቱ ሪፈር ዘ ክሪሚናል ኮድ ይሄ ሁለት ወር ነው የሚያስቀጣው አንችልም እንግዲህ ምን ማድረግ አንችልም ብላችሁ ታይፍ ነው ሰውየው is it feasible? It is not feasible. ስንቶቻችን እኔ ራሱ አንድ ወንጀል ተጣጣችልኝ ስንት ነው የሚያስቀጣው ትልኝ አካናይ ነው it ሪፈር ካላሮኩኝ ክሪሚናል ኮድ ስለዚህ ታዲያ በጣም ኮመን ነው የተለመዱ ወንጀሎች ካሉ ነው መስተቀር ወንጀሎችን እንዳላቃለው ስንት ወንጀል እንደሚያስቀጡ ስንት እንደሚያስቀጡ አይተበቀብኝ ስንት ነው so it is not feasible. Doesn't seem to be logical. And you may research the preparatory work of this criminal code, this criminal procedure code. Fisher, Fisher has made a very good work. Even we Ethiopians haven't done. Foreigner or no, bigger. He's very conservative, very responsible person. He has written a very good book, and you can find it in the library. Though it is old for researching, it is very interesting. So you may refer the justifications, the underlying reason for that. If Fisher has. The problem is, this criminal procedure code has been copied from here and there. It has been copied. The very big problem of this criminal procedure code it is copied from behind there so that you do not find a justification which is consistent. Okay. Anyhow, it doesn't seem to be logical, but that's what the law says. And we have to accept it, whether we like it or not. It is the order of the law. It says it has to be simple imprisonment. It has to entail. And one important thing is you shouldn't forget is the offense shouldn't be punishable upon complaint. You do not have to forget it because it is already provided under Article 21. The offense shouldn't be punishable upon complaint. So the other thing, first, so arrest without warrant is possible whenever the offense is a flagrant offense. In such cases, arrest can be made without a warrant either by private person or member of the police. This is one exception for Article 49, which says arrest with warrant is a rule, arrest without a warrant is an exception. So this is one exception. The other exception is in the cases provided under Article 51. Arrest without warrant by the police, it says. So whenever the conditions under Article 51 are fulfilled, it is again possible to arrest a suspect without a warrant. But one important point is it can be made only by the police. It is only the police that can arrest in such cases. Okay? So very quickly read Article 51. What are these conditions? Arrest without warrant by the police. So Article 1. Any member of the police may arrest without warrant any person, Article A, whom he reasonably suspects of having committed or being about to commit an offense punishable with imprisonment for not less than 1 year. And I am not comfortable with the law, with the criminal procedure code in setting this, years, like not less than, something like that. Because it is very difficult to appreciate. Anyhow, it says if it entails simply with imprisonment of not less than 1 year, then police can arrest without warrant. Police can arrest without warrant. Whom he reasonably suspects of having committed or being about to commit an offense. Police may suspect you, for example. He may suspect that whenever he sees the circumstances, your appearance or the way you are behaving, he may suspect that you have just committed an offense or you are about to commit an offense. So this is something in line with the duty of the police to prevent crimes. So police has a duty to prevent crimes. So if police reasonably suspect that you are about to commit an offense or have committed an offense, then police can arrest you without a warrant. Police can arrest you without a warrant. So by so doing, police will sustain the peace and stability of the nation. And Article B, who is in the act of committing a breach of the peace? Who is in the act of committing a breach of the peace? What do we mean whenever we say breach of the peace? It is something, it requires you to refer to the criminal court. There are crimes against the peace and tranquility of the nation. The criminal court says. Criminal court has sections. Crimes against the constitutional order, it says crimes against the peace and stability, tranquility of the nation and the like. So you will find under the criminal code crimes that amount to breach of the peace. You will find in the criminal code. Article 490 and the following provisions from the criminal code. It is like the crimes are like disturbances against the public. Like for example, whenever a meeting is about to be carried out or discussion, an assembly or something like that, if you disturb that, then it is crime against the peace. Such kinds of offenses. So in such cases, police can arrest without warrant. Police can arrest without warrant. In Article C, who obstructs a member of the police while in the execution of the duties, or who has escaped or attempted to escape from lawful custody. This is a very controversial provision. Insofar as the use of force is concerned. Who obstructs a member of the police while in the execution of his duties, or who has escaped or attempted to escape from lawful custody. So that person was arrested by the police, or was in custody, under police custody. So if he escapes that, then no need of going to the court and seeking court warrant or an arrest warrant. No need of having that. It is possible to arrest without warrant. It is possible to arrest without warrant. And some people may obstruct the activities of police. See, these people can also be arrested without warrant. And B, who has evaded or is reasonably suspected of having evaded police supervision, is something similar to sabbatical C. And E, who is reasonably suspected of being a deserter from an armed force or the police force. Once you join an armed force, it is very difficult. You have to reasonably think. You have to critically think before deciding to join the army. And once you join an army, you are not expected to do all this. You cannot change your mind. So if you desert an armed force or the police force even, then the police can arrest you without court warrant or without an arrest warrant. ሚሊቴሪ ውስጥ ከገቡ በኋላ ከሚሊቴሪ ለመውጣት የሚፈልጉ ሰዎች አሉ። ፖሊስ ሰራዊት ውስጥ ከተቀላቀሉ በኋላ ከፖሊስ ይቅርብኝ ብለው ለመውጣት የሚሞክሩ ሰዎች አሉ። that is not allowed. Okay? Then those people can be arrested without a warrant. Actually, this was a very familiar situation during the regime, because at that moment people were forced to join the army. The youngsters were forced to join the army. Actually, it is civic responsibility, by the way. In some states, as you might have heard, it is mandatory. You couldn't join this university without first joining the army. In some cases, it is a duty. Civic responsibility, widely accepted principle. But you have to be convinced. Otherwise it will be a human rights violation. You have to be convinced. But once you join, you cannot desert it. Okay, now sabbatical F, who has in his possession without lawful excuse house-breaking implements or weapons. So if police observes that you have house-breaking implements in your hands, police may reasonably suspect that you are going to do something wrong. Then police can arrest you. ቤት መሰርሰሪያ ምናምን ነገር ከያዛችሁ የቤት መሰርሰሪያ ምናምን ይዛችሁ ስትሄዱ ካየ ፖሊስ ሊይዛችሁ ይችላል፣ አሬስት ሊያደርጋችሁ ይችላል ማለት ነው። እናንተ እንግዲህ በጉልበታችሁ አድራችሁ የምትበሉ ሰዎች ትሆኑ ይችላላችሁ። ማስረዳት ነው እንግዲህ ኧረ እኔ ሰራተኛ ነኝ፣ ጉልበት ሰራተኛ ነኝ፣ ቤት ሰርሳሪ አይደለም ብላችሁ ማስረዳት ይጠበቅባችኋል። ፖሊስ ግን አሬስት ማድረግ ይችላል if reasonably suspected. otherwise እያወቀ ለምሳሌ በግሩፕ ሆናችሁ ለጉልበት ስራ እንደምትሄዱ እያወቀ ምናምን ይፈቅድልኛል ብሎ አሬስት ማድረግ ይችላል if reasonably suspects. You understand the logic behind this. It is to protect the public. It is to prevent crime from happening. And sabbatical F, who has in his possession without lawful excuse. Okay, we are considered G, who has in his possession without lawful excuse anything which may reasonably be suspected of being stolen or otherwise obtained by the commission of an offense. If police suspect that you have in your possession something is stolen, So, it is very easy for the police to identify such kinds of people, because people who hold, it's very, even you can understand and you can distinguish these kinds of people. A person who has in his possession his own property and a person who has hold the property of another person or something stolen. It is very easy for the police to identify. Okay, so in such cases, police can arrest and investigate. And sabbatical H, who may reasonably be suspected of being a dangerous vagrant within the meaning of it's a dangerous vagrancy proclamation. So if police suspect that that person is dangerous vagrant, then police can arrest that person. dangerous vagrancy proclamation. Vagrancy proclamation allows arrest without warrant. The dangerous vagrancy proclamation allows, do you understand the wisdom behind the vagrancy proclamation? It is very controversial, by the way. You might have seen it. So these are exceptions, okay? Article 50 and 51 are exceptions. In such cases, arrest without warrant is possible. Article 15, arrest during flagrancy. In case of flagrancy, arrest without warrant by a police and by a private person is possible. But under Article 51, arrest without warrant is possible only by the police, and the conditions should be fulfilled. So, some scholars argue that Article 50 and 51 give very wide jurisdiction to the police, very wide power to the police. They say almost all crimes are regarded as flagrant. I mean, almost in all cases, in many cases, police is allowed to arrest without warrant. It is very wide, they argue. Like, for example, look at Article 51, subarticle 1A, for example. You know, whom you reasonably suspect of having committed or being about to commit an offense, punishable with imprisonment for not less than 1 year. You know, it means 1 year and above. Even the first case, greater than 3 months simple imprisonment, it means it covers a number of offenses once it is a flagrant. And Article 51 covers a number of crimes. It says, Article A, for example, not less than 1 month, 1 year, isn't it? With imprisonment for not less than 1 year. It means it covers a bulk of offenses. So it means police is given very wide power, as some people argue. So this is not appropriate. People criticize this provision because arrest without warrant is something which endangers the liberty of individuals. If police is allowed to arrest without warrant, then our liberty will be at risk. Our liberty will be at risk. So you cannot ask. You cannot ask. For example, if you are under the possession of an implement, like the one provided under Article 51, how to implement? ቤት ለመሰርሰር ቢጠቅም መሳሪያ ይዛችሁ ብትሄዱ እኮ ነው መጠንቀቅ አለባችሁ። ምክንያቱም ፖሊስ ተፈቅዶለታል። መጥቶ ጋማችሁ ሊይዛችሁ ይችላል። አሬስት መደረግ በነገራችን ላይ as I might have said last time, አሬስት መደረግ is very shocking. ያሰቃል። አሬስት ተደርጎ የሚያውቃል? የሚያውቃል? እንዴ መኖር አለበት። Yes, very good. So how do you feel it? Did you enjoy it? Restricted. It has to be restricted. But this law has given very wide jurisdiction to the police. Then, how is arrest made? How is arrest made? How is arrest should be made? But before that, let's very quickly read articles 52 up to 55 very quickly. And let's see Article 53. This is provided under Article 50 and 51. In other cases, police should get an arrest warrant. So, how is warrant of arrest executed? How is an arrest warrant executed? Indeed, no. How is it executed? Indeed, no. We don't know very quickly. Indeed, not indeed. The police indeed mandate under the we don't know very quickly. Because sometimes you may think that arrest warrant is some document issued by a court, we said last time. But what if, for example, the offense was committed on Friday, like around 7 p.m., for example? Need no police arrest warrant. So you could have it. Now, it is not a flagrant offense and doesn't fall under Article 50 and 51. It is not vagrancy. The offense is not vagrancy and doesn't allow the police to arrest without warrant. Okay? And police, after receiving an accusation, he has reasonably believed that Mr. Y has committed an offense. Mr. Y has committed an offense. And police issued summons to him. Mr. Y knows his rights very well. He ignored it. police is not allowed to arrest without warrant in such cases, isn't it? So he is preparing, mind you. He is preparing. But unfortunately, it doesn't fall. He is a very careful person. Because if you see, for example, Article 51 sub-article D, who has evaded or is reasonably suspected of having evaded police supervision, he says, and mind you, it doesn't fall. It doesn't fall. That person is very careful so that he has taken all cares. He has taken all cares not to enable the police to arrest him without a warrant. Okay? ስለዚህ እንግዲህ ወበዝ ሌባ ብትሆኑ ከሆነ ሰውየው ፖሊስ በተቻለ መጠን ያለ ዋራንት እንዳይዛችሁ መጠንቀቅ አለባችሁ ማለት ነው። ሌብነት እየመከርኳቸው ነው። ስለዚህ አርቲክል 51ን በደንብ ማየት አለባችሁ። ያለ ዋራንት እንዳይዛችሁ አድርጋችሁ መጠንቀቅ አለባችሁ። እዛው ፎሎ አያደርግም። ሰውየው ተጠርጥሯል፣ then ሊያመልጥ ነው በቃ። ግን ፖሊስ አውቋል ሊያመልጥ ነው። ኮርት ዋራንት ገና ከኮርት ጋር ሲጨቃጨቅ ድረስ ሰውየው ሊያመልጥ ነው። እንዴት ያደርጋል? So getting arrest, getting an arrest warrant should be very easy and it shouldn't be very bureaucratic. It shouldn't be very bureaucratic. Okay, that is why the law has also made the possibilities of getting an arrest warrant very easy. Let's look. Article 53 says, warrant of arrest may be issued on the application of any investigating police officer by any court. You see, by any court. And the police shouldn't worry about the jurisdiction of the court. It can be issued by any court and shall be addressed to the chief of the police in the that in which it is and sub-article to a warrant may be issued at any time and on any day of the year, mind you, even Kadamim Bagudum, and at any time it says, but anytime, and it says anytime, that is why, because it may create favorable environment for the suspect to escape justice, that is why. And a warrant of arrest may be executed in any part of Ethiopia, in any part of the empire, by any member of the police. Anywhere arrest warrant ካለው arrest warrant ይዙ anywhere ተደበቁ ኢትዮጵያ ውስጥ ሆናችሁ ድረስ የመያዝ መብት አለው። ማስፈቀድ ምናምን ብሎ ያስፈልጋል። If it is cross border ማለት more than two regions የሚያገናኝ አይነት ወንጀል ከሆነ ከፌደራሊዝም አንፃር የሚታይ ነገር ይኖራል። anyways የፌደራል ወንጀል ከሆነ ለምሳሌ ፌደራል ፖሊስ ካን ኤክስኪዩት የፈለገበት ሄዶ አሬስት ማድረግ ይችላል። አሬስት ዋረንት ካለው ድረስ And when warrant of arrest to be issued, Article 54, a warrant of arrest shall only be issued where the attendance of a person before the court is absolutely necessary and cannot otherwise be obtained. It is a provision which aims to check the powers of the police. As a police, arrest warrant for the way to it has to be something absolutely necessary. ሰውየውን በእርግጥ ማግኘት የግድ ነው። የሰበሰበው ማስረጃ ኦኬ የግድ ሰውየውን መመርመር ያስፈልጋል። ምክንያቱም ፖሊስ ብሎ በቃ ገሌ ጠርጥሬዋለሁና ፖሊስ በተጠየቀ ፍርድ ቤት በተጠየቀ ቁጥር አሬስት ዋራንት ኢሹ የሚያደርገው አስቸጋሪ ነው። አሬስት ዋራንት በተጠየቀ ቁጥር አንድ ፖሊስ መጥቶ ለፍርድ ቤት አሬስት ዋራንት ዘላለም እንዲይዝ ነው ሲል ፍርድ ቤቱ ዝም ብሎ ኢሹ ማድረግ የለበትም። ቼክ ማድረግ አለበት። That's what Article 54 dictates. ለምንድን ነው ዘላለምን አሬስት ማድረግ የግድ አስፈላጊ ነው? ምን ማስረጃ ይዘህ ነው? ምንድን ነው የሰማው ኢንፎርሜሽን የሚለውን ቼክ ማድረግ አለበት ፍርድ ቤቱ። otherwise police may abuse its power. እና ሰሞኑን ለምሳሌ ተጠቅመህ ዘላለም አመጣም ማለት I have to check. You see? It's a means of checking the powers of the police. And Article 55, application for warrant in urgent cases. In cases of urgency, the investigating police officer may apply for a warrant by telegraph. In such cases, the application to the court in question shall be confirmed in writing within 24 hours. Now,
at this moment ያው ኢሜል የሚባል ነገር በወቅቱ ስላልነበር በኢሜል by any technology you know it has to be replaced it has to be replaced you know it has to cope up with the technological advancement so by any technology it may be confirmed okay then very let's consider how arrest is made ያቂ ካላችሁ ሆልድ አድርጉትና ብለህ ጠይቁኛላችሁ how arrest is made article 56 okay very quickly Istanbul article 56 the police officer making an arrest shall first establish the identity of the person to be arrested so police has to check for example if the police according to the information it received is that the offense is committed by Mr. Abebe or Mr. X or Mr. what have you, then police has to check whether it is Abebe actually. Okay, first the police has to ask his identity documents. Is it really that person? It's very important. There are some people who mistakenly spend a lot of time in custody. And finally, imagine after spending like months, you may be told that, oh, Ashanafi, I'm sorry, we are mistaken. Oh, mind you spend months, like 6 months, 7 months, from your life, from your limited age, taking 7 months. It's a very great loss. You may be a student, isn't it? You have lost a lot of things. Okay? There is no compensation in our country. So only takes that the police, if at all he is ethical, is excuse us, he may say. Or he may say, in many cases, I shall not be one mistake, walk away. You may go, oh, thank you. You have to say thank you. Otherwise, he may bring you. So that's very difficult. So police has to establish the identity of the suspect. Okay? So Article 2. Where the arrest is made with the warrant, the police officer shall read out the warrant to the person to be arrested and shall show it to the person arrested if he so requests. Okay? So you may say, for example, whenever police comes to arrest you, do you have an arrest warrant? You should say, by the way. You don't have to be afraid. Because there are some police officers who are very disciplined. They may say, yes. Then you don't have the right, let me see it. You have to read. Because there may be a mistake. Then in many cases, people are wrongly arrested. In many cases. Okay? So you have to check if it is really you. And you have to read the reason for the arrest. So you will get prepared. Now, ብዙ ጊዜ አረ እኔ አይደለም ስትሉ ማንም አይሰማችሁም። ግን አንተ ብቻ ነህ እውነት ዘላለም ነህ አዎ ካላችሁ ግን እኮ እዚህ ውስጥ አረ እኔ እኮ እዚህ ምናምን ማንም አይሰማችሁም። ይሁን ቤቴክን ከዛ በኋላ እንግዲህ በጣም ከባድ ነው። በጣም ከባድ አንዴ ከፖሊስ ስትገባችሁ very difficult mistake. So you have to know your right. You should ask arrest warrant. Do you have an arrest warrant? And you should ask him to give you the arrest warrant and you should read. Okay? Because it helps you to prepare. You know, if you have actually involved in an offense, in that offense, for example, you read the warrant, because it may say, for example, by shooting the gun, it may say, you haven't shot the gun. And that it may say, on April the full one. Is it April 1? 31. I was about to fool you. You shouldn't be fooled. Okay. So, police who appeals the full no will here. Then you have to be careful. You have to read it carefully. Then it makes it the time is mistake. On Wednesday, April 1, Mr. X in Jima town, blah blah it says. You are confident. Oh, I am mistaken because I was not in Jima by that moment. You get prepared, you see. You will get prepared. Reading is very important. Reading the document is very important to you. And Article C, he shall then actually touch or confirm the body of the person to be arrested unless there be a submission to his custody by word or action. Mind you, so not to your privacy right is protected, your liberty, personal integrity, dignity is protected by the law. He shall then actually touch, he shall actually touch or confine the body of the person to be arrested unless there be submission to his custody by word or action. So that's the warrant. ይዞ ሲመጣ በቃ ይሄዳል። የት ነው ፖሊስ ጣቢያው ካላችሁት እሺ ሰውነታችሁ ማንካት አይችልም። ከተገለበጠ ሜቢ እንደ ጓደኛ መስላችሁ ቤት ይችላልካችሁ። ኦኬ ግን ሬዚስት ካደረጋችሁ there are some people who resist that እኛ የተለያየ ጸባይ ያለን ሰዎች ነን። ቫዮለንት የሆኑ ሰዎች አሉ እንደዛው የሚያስቸግሩ። እንደዛ አይነት ከሆነ ግን እንግዲህ ካልተች ኦኬ or confine ማድረግ ይችላል። then if such person, Article 4, if such person forcibly resists the endeavors to arrest or attempts to evade the arrest, such officer may use all means proportionate to the circumstances to effect the arrest. Okay, you see, proportionality requirement is there. There are some people who try to evade it, knowing that, like whenever the person looks at the police, you know, it's very What's the police investigation? So he may, you know, want to evade justice. Then, you know, in practice, okay, first let me tell you a very important thing: proportionate. It says, resist Karadaga. Resist Karadaga. Police has to use proportionate means. That is a very important element that restricts the abuse of power of the police. Proportionality. Proportionality, circumstances, the circumstance will be taken into account. The means that that person is using to evade justice is taken into account. Okay? The physical appearance of that person in the police, the respective appearance of the police and the person will also be taken into account. Okay? በቀላሉ በአንድ ጥፊ የሚቆጣጠረው ነገር መሳሪያ ወይም በሰደፍ የሚያጋጨው ከሆነ ኦኬ ፕሮፖርሽናል አይደለም ማለት ነው። አንዳንድ ሰዎች አብዛኛው አንወድም ያ ፖሊስ ይዘን ለዚህ በቃ ምናምን ከዛ አራራ ይሳለኝ እንዴ ብሎ ያ ሰው እየተጥሪ ይችላል። it has to be proportionate circumstances ለሰርከምስታንሱ ነው። አንዳንድ ጊዜ ደግሞ በጣም ከባድ ሁኔታ ይፈጠራል። ተከከኝ ብሎ ምዝዝ ያደረገው ነገር በጣም ያስፈራ ሊሆን ይችላል። ሽጉጥ ምዝዝ ቢያደርግስ police has to take proportionate means. Self defense comes into picture. Okay? So it has to be proportionate. In Article 5, the provisions of this article shall also apply to bench warrant. The bench warrant ማለት ፍርድ ቤት አልቀርብ ያለ ሰው አልቀርብ ሲል ፖሊስ ታዘዝና ታስሮ ይቀርብ የሚባል ትእዛዝ ይጻፋል። እሱም ማለት ነው። ኦኬ እንደዚህ ያኔም ይሄ ፕሮቪዥን ተግባራዊ ይሆናል። Then proportionality like still it is confusing, it is unsettled. What does it mean proportionality? Like does it mean for example the person is escaping already? Already አመለጠው ፖሊሱን ወነ ተፋም ፖሊስ ነው በጋጣሚና አመለጠው ሮደ ፖሊሱ ሲነቃ ያመለጠና መሳሪያም ተቆስ ይችላል። What does it mean? I mean, is it allowed? You know what in practice they used to do? Which a very reliable person or source disclosed. በጣም አስቸጋሪ recidivist, you know recidivist, በተደጋጋሚ ከፍርድ ቤት ያሰለቻል። ፖሊስ ጣቢያን በጣም የለመደ ሁሌ የሚያስቸግር እና ብዙ ጊዜ ፖሊሶችን የሚያስቸግሩ ምናምን ወንጀለኞች በጣም notorious criminals, whenever notorious criminals, you know, disturb the justice process, ምን ያደርጋሉ? አውቀው ከማረፊያ ቤት ወደ ፖሊስ ጣቢያ ወደ ፍርድ ቤት ሲወሰዱ ለቀቅ ያደርጓቸዋል።
then criminal tomato lives in Kalai, sniper then the sniper, so he will be assassinated. Does the system in Takamalun, as I heard? No, is it allowed? As I'm in the police justified. He is a recidivist. He has killed our members. The very black record is a recidivist. So he was about to repeat what he has been doing so far. So police took proportionate means. And anyhow, still it is unsettled. And there is a law now underway. The Attorney General is passing the use of force, a proclamation on the use of force. The use of force by the police. This proclamation, I expect, and it is expected to answer or to settle these controversies. አለበለዚያ ከፍርድ ቤት እያመለጠ ያለ ሰው ለምሳሌ አርቲክል 51 እንዳየነው ከፖሊስ ማረፊያ ከፖሊስ ቁጥጥር እያመለጠ ያለ ሰው አሬስት ዊዛውት ዋራንት ይቻላል ነው። አሬስት ሲደረግ ግን ሬዚስት ካደረገ እንዴት ነው? ሬዚስት አድርጎ ካመለጠስ እንዴት ነው የሚደረገው? ከኋላው ተኩሶ ነው እንዴት ይቻላል? What do you feel, by the way? I mean, this law is in the process. So, what is your opinion? Should police be allowed in such cases to kill? If you are a police, if you were a police, what do you think? What should be the scope of proportionate means? What should be the scope of proportionate means? Anybody wants to say something? So, very unproportional force to arrest that person. Even whenever that person submits, to the order of the police usually uses force. An arrest warrant in many cases is used as a green light for the police to use force. As long as police has arrest warrant, they usually beat people. That is not how. It shows how the law enforcement authorities should be trained. Actually, it's enough. Please, Martha. Of course, the procedure, there is a very intricate, very, difficult problem of making police accountable. But if you ask me what the law says, yes, like any other individual, police will be accountable for his action. Police will be accountable for his action. But the problem is, usually, they are raising this as a defense. Proportionality. After killing that person, or after seriously, not only killing, after seriously injuring that person, placing him in a very difficult situation, they raise this as a defense. Who investigates? The other police officers. Police are accountable. That is the problem, Their friends are investigating the matter. Imagine. So let's say, like in every profession, they prefer to hide the matter because it is their friend. That's a very serious problem. In many cases, an independent organ or an independent institution is not established for this purpose. The Human Rights Commission's power nowadays is improved actually, but it's very insignificant. Human Rights Commission usually investigates and presents reports. Otherwise, it doesn't seriously follow whether that person is held accountable for his action. There is Human Rights Commission. But if you ask me, the law says that if the police abuses his power, one, there is disciplinary violation. It is a disciplinary violation. Secondly, it entails criminal responsibility. Okay? But in court, in many cases, they try to justify it under the guise of proportionality. They say the law allows us to use proportional means. Under the circumstance, it was proportional to kill that person. They argue this way. And the scope of proportionality is not clearly articulated in the law. That is why now the government is in the process of revising that law, the process of promulgating a law on the use of force by the police. And we hope that this controversy will be resolved by this law. But the point is, it is very difficult to
hold the police accountable for this excessive use of force. በጣም አስቸጋሪ ነው። Asking me that in arrest without warrant, private persons, private persons are allowed to arrest without warrant under Article 50. So in such cases, if the person resists, is it possible? Is this proportionality also applicable? Article 56, is it applicable to private persons as well? What do you think? Because Article 15 clearly, Article 56 clearly says, it is clearly talking about police, isn't it? Talking about the police. But it is not talking about a private person. So, is it applicable for private persons? That's the question. How do you think?
ሲደርስበት በራሱ አሬስት ለማድረግም ባይሆን ሲደርስበት የመከላከል መብት አለው።
Yes.
ስለዚህ እዛ ጋርም ያንን ሰው ሊይዝም ቢሆን የደረሰበት የመከላከል መብቱ የተጠበቀ ስለሚሆን ፕሮፖርሽናል ፎርስ መጠቀም ይችላል።
Okay, very good point. She's saying that he has to use to inflict damage on you. If he is about to inflict damage on you, you have to protect. You protect yourself. Then you protect yourself and you can go without arresting him. But the law asks you under Article 50 to arrest. How can you do? ማለት ምን ማለት ነው? ግልጽ ካልሆነልሽ ሰልፍ ዲፌንስ ማለት የግድ ሰልፍ ዲፌንስ አሬስት ማድረግን የሚፈቅዳል ማለት አይደለም። ሰልፍ ዲፌንስ ማለት አንድ ሰው ልክ አሬስት ታደርጊው ስትይ ሰልፍ ዲፌንስ የሚፈቅድልሽ ምንድነው? ያንን ፎርስ ብሎክ ማድረግ ብቻ ነው የሚፈቅድልሽ። ራስሽን ትከላከያለሽ እንዳይመታሽ። የሚመታሽ ከሆነ ወይ ትሸውጂዋለሽ፣ የግድ መማታት ካለብሽ ትመጪዋለሽ። ከዛ በኋላ ግን አሬስት ማለት ሌላ ነገር ነው። ኦኬ። ስለዚህ ሰልፍ ዲፌንስ የሚፈቅድልሽ ራስሽን እስከ መከላከል ድረስ ነው። አሬስትን አይጨምርም ነው።
ኮን ያልኩት አሬስት የማድረግ መብትም አለኝ አይደለ? ማለት እንደ ፕራይቬት ፐርሰን ይችላል ተብሏል እዛ ጋር እና የምችልበት ሰርከምስታንስ ነው ያለው።
አስፈራርጀሽ ቆምስ
እኮ ካስፈራራኸኝም ያንን ራሴን እየተከላከልኩ ይዘሃለሁ።
እንዴ ማስፈራራትና እኮ ዴንጀር ይያያላ አትንኪኝ እያልኩሽ አንቺ መተሽ እንግዲህ መያዝ ስላለብኝ ካልሽ እሱ ሌላ ነገር ነው። ሰልፍ ዲፌንስ አይባልም። ኦኬ ሲምፕል ፖይንት we do not consider it as a self-defense. Anyhow, any other point who wants to add, please? Resist ያደረገን ሰው ሄደ ሰልፍ ዲፌንስ ማለት ነው። ዴንጀር ሲመጣባችሁ ተከላከሉ ነው አይደል? አትምጣብኝ እያለ ነው ሰው። አመጣብኝ አትንካኝ እያለ ነው። ሰልፍ ዲፌንስ ነው። ስለዚህ ሄጄ መያዝ አለብኝ አትችልም። ዴንጀር አመጣብኝ አትደርስብኝ ያለ። Okay, anyhow, the point is the provision says Article 56 police ነው የሚለው not ነው. It says police, and it doesn't include private persons. It doesn't include private persons. But you can justify, maybe for stronger justification. For a stronger justification, it should also apply to the police and to the private persons as well. የሚል አርጉመንት ካለመጣችሁ በስተቀር it talks consistently police ነው የሚለው consistently. But there are other laws. ከክሪሚናል ፕሮሲጀር ውጪ ሂውማን ራይት ፕሮቪዥኖችን ጀስቲፋይ አድርጋችሁ ካላረጋችሁ በስተቀር ኮንሲስተንትሊ ክሪሚናል ፕሮሲጀር ኮድ ጋያችሁት it is elusive. So there are other strong grounds to require private persons to use reasonable force as well. Now it's a very good point that you raise. Hey, ምናልባት ፕሮክላሜሽን ይሄን ነገር ኦቨርሉክ ካደረጉት it's very difficult. They shouldn't overlook it. Any other question? Okay, very interesting. Now let's go. What is the process after arrest? Very quickly, Article 28. Article 29. Procedure after arrest. Arrest is made, then what follows? So it has to be clear at this point that arrest means making the person under the custody of the police. የግድ ፖሊስ ጣቢያ መሆን አይደለም።
ከዚህ እንደተረዱት ያ ሰውዬ ፖሊስ ጣቢያ ከመጣ ብቻ ነው አሬስት ይባላል እንጂ ሰውዬው በፖሊስ ቁጥጥር ስር ከሆነ አሬስት ነው በቃ። ያ ደግሞ በፎርስ ሊሆን ይችላል፣ በሰሞንስ ብቻ ሊሆን ይችላል። ሰሞንስ ሪጀክት አድርጎት ወይም ዲክላይን አድርጎ አሬስት ዋራንት ኢሹ ተደርጎ ሊሆን ይችላል። ኦኬ በአሬስት ዋራንት ሊሆን ይችላል። ወይም ደግሞ ዘ ኦፌንስ ኢዝ ፍላግራንት ኦፌንስ እጅ ከፍንጅ ተይዞ ሊሆን ይችላል። ዘ ኤንድ ሪዛልት ኢዝ ኢፍ ይሄ በህግ ጥላ ስር ምናምን ይላሉ አይደል በተለምዶ ሰዎች if the person is under the control of the police then we call it is arrest. Then what will follow after arrest? What will follow after arrest? ከፖሊሱ ጋር ያላችሁ ቆይታ እስከምን ድረስ ነው ሆነ ያለበት ነው። Okay, so please very quickly read article 29. After arrest, where the accused has been arrested by the police or a private person and handed over to the police, Article 58, the police shall bring him before the nearest court within 48 hours of his arrest or so soon thereafter as local circumstances and communications permit. The time taken in the journey to the court shall not be included. Article 2, the court before which the accused is brought may make any order it thinks fit in accordance with the provisions of Article 59. Sorry. So this is a very Article 59, as you shall see right now, is still very controversial. Anyhow, the point is, after arrest, the person should be immediately taken to the court, the nearby court, within how many hours? 48 hours, mind you. 48 hours. 48 hours. The person has to be taken to the court. Because court is usually said as a guardian of human rights. Okay? So we have to be brought to court because it's an executive organ. The police is an executive organ. Its actions has to be controlled by the judiciary. The actions of the police should be controlled by the judiciary. So it is one means of checking the actions of the executive branch of the government. One means of checking the actions of the executive branch of the government. You have to be taken to the court within 48 hours. Okay? Any question? Yes. After arrest, a person has to be transferred to the police. ለፖሊስ መሰጠት አለበት። ሶ 48 ሰዓት የሚቆጠረው ለፖሊስ ሃንድ ኦቨር ከተደረገ በኋላ ኦኬ after the person is handed over to the police, once the person becomes under the control of the police has to present that person to nearby court within 48 hours. Okay, within 48 hours. And this time is usually abused. And actually the law says this 48 hours doesn't include the time taken to take that person to court. Police ያለበት ቦታ ምናልባት ሩቆ ሊሆን ይችላል ከፍርድ ቤቱ እና አቅራቢያ ፍርድ ቤት የለም። ኦኬ ፖሊስ አሬስት that person አቅራቢያ ፍርድ ቤት የለም። ምናልባት ፍርድ ቤቱ ባለመድረስ ነው አንድ ቀን ሊፈጅ ይችላል። ኦኬ አንድ ቀን maybe countryside or some very far area. So ያ ታይም አይቆጠርም። ያ ታይም ይቀነስና ፖሊስ ቁጥጥር ስር ከገባ በ48 ሰዓት ውስጥ ማድረስ አለበት። በ48 ሰዓት ውስጥ ማድረስ አለበት። And that is why it says so soon thereafter as local circumstances and communications permit. And that they are the base. Actually in Ethiopia we are living in a very poor country. There are local circumstances may not allow the police to bring within 48 hours. The recent በቅርቡ ዊትነስ ፍርድ ቤት ብዙ ኬዞች በጣም የሚገርሙ ኖቶሪየስ ኬዞች እያየን ነው።
You have to closely follow up, by the way. Because every day issues of criminal procedure are raised. On the Federation Samacho cases, the criminal procedure issues in the Senate. So you have to analyze the issues as a professional in light of the law. You have to analyze anything related to arrest concerns you. Okay? So, now, very recently, integration conflict is there was an argument there. How do you see it? The ex-officials, like Sabatnaga, raised the defense, saying, it exceeded 48 hours. I was arrested in Tigray, and it took many days. So, it is a violation of my rights. That was the defense raised. So, what should be the response? If you were a judge, the previous, the ex-top officials, they complained that it took more than 48 hours for them to be brought to court after arrest. Arrest ከተደረጉ በኋላ በ48 ሰዓት ውስጥ ምናልባት አቃቤ ሕግ ብትሆኑ ምን አይነት ዲፌንስ ነው የምታነሱት? ፕሊዝ ፎርስ ሜጀር እዚህ ጋር ፎርስ ሜጀር አለ። ልመና ሕግ መሰረት አድርገህ ነው you have to base your argument with zero as a lawyer. What provision would you say, would you raise? Because it doesn't say force measure. Or can you interpret it to include force measure? Force measure መጨመር እንችላለን ኢንተርፕሬት አድርገን ይሄንን yes ምናልባት ሰርከምስታንሱ ወደ ፍርድ ቤት ለማቅረብ Tigray region, it is not, settled, and the judiciary and other law enforcement organs are not working. So they had to be taken to court in other area, and it does not justify the delegate. But okay, as a lawyer, always you have to base your argument with the law. Gee, it doesn't work if you are a lawyer. ምክንያቱም ተከሳሽ ፈለገው ዲፌንስ ሊያነሳ ይችላል። ለምን አሜሪካው ወስዳቸው አላሳከማችሁኝም ሊሉ ይችላል። ህጉ ከፈቀደለት ማለት ነው። But there has to be logical and an argument which bases itself on the law. Okay, so በ48 ሰዓት ውስጥ ፍርድ ቤት መቅረብ አለበት። As local circumstances communicate permit, the time taken in the journey to the court shall not be calculated or included illegal. The court before which the accused is brought may make any order implicitly in accordance with Article 59. ምን ማድረግ አለበት? አሁን what do you reasonably expect whenever the law requires the police to take you after being arrested to court? What is your expectation? You prefer to be taken to court, isn't it? People are repeatedly complaining that after being arrested they are not taken to the court, whereas they should have been taken to the court. I was arrested by the police 10 days ago, but still now I am in the police detention. People complain repeatedly. What do you think they will get if they are taken to court? ከተያዝኩ በኋላ ፍርድ ቤት አልተወሰድኩም ምንድን ነው ግን ፍርድ ቤት የሚያገኙት? ፍርድ ቤትስ ምን ማድረግ አለበት? What do you think should be the role of the court after you are taken to the court? Okay? Arrest law means Fisher is above article as that. Very interesting. I will send you when you are communicating with Telegram. So I will send to either Martha or Kansa, to both of them. Okay, so that you share and read it. Very interesting article. Okay, but what do you reasonably expect from the court, or what should be the role of the court before reading Article 59? Article 59 ከማገባቸው በፊት let me raise a brainstorming question. What do you think should be the role of the court? ከተያዛችሁ በኋላ ፍርድ ቤት
ብትወሰዱ ትመርጣላችሁ። ብዙ ሰዎችም እየመረጡ ነው። ፍርድ ቤት አትወሰኩም። ፍርድ ቤት ሮሉ ምን መሆን አለበት? ልክ ስትመጡለት ምን አይነት ሮል ሊኖረው ይገባል? ምን ይመስላችኋል? What should you think the role of the court be? The court should have power to check whether the arrest was lawful or not. But what if the court finds that the arrest was unlawful? And even before that, how should the court determine whether the arrest was lawful or not? That should be the first question, actually. How should the court determine whether the arrest was lawful or not? He said the court should check whether the arrest was lawful or not. Whether the arrest was lawful arrest. When do we say that there is a lawful arrest? Lawful arrest in the language still yes, please. By evidence of the police to check whether arrest was under the circumstances arrest was necessary or not. Mind you, you remember, after an accusation is made, we have seen Article 25. Whenever police believes that the crime has been committed by a certain person, police should arrest that person, isn't it? By using someone, the following provisions will follow. So there has to be, justifiable ground which, which leads the police to believe that the crime has been committed by Mr. X. ስለዚህ ምን አይነት መረጃ ይዘን ነው ደግሞ ኤክስን አሬስት ለማድረግ የወሰንከው የሚለውን ፍርድ ቤቱ ማየት አለበት ነው። ምክንያቱም አቢዝ ይደረጋል ብዙ ጊዜ ፖሊስ has to check whether there is lawful ground to arrest Mr. X. This is it. So if there is lawful ground, then the court will check whether there is no lawful ground. But what if the court checks that there is no lawful ground? ማስረጃዎችን ሳያቸው ከኤክስ ጋር ምንም ያገናኘው ነገር የለም። ስልጣን ስላለው ብቻ ነው ፖሊስ ብሎ ያያዛቸው። ፖሊስ ፍርድ ቤቱ የተሰጠውን ጥቆማ ያለ እንዳየነው እኮ 25 ጋር ማስረጃዎችን ሪካርድ ያደርጋል 23 Article 24 recording of statement and circumstantial evidence ሁሉ የወንጀሎቹ ምናምን ሪካርድ ያደርጋቸውን ካየ በኋላ በቃ ሚስተር ኤክስ ፈጽሟል ብሎ ካመነ ነው ፖሊስ አሬስት ማድረግ የሚችለው እንዳየነው አሬስት ለማድረግ ፕሮሰስ የሚጀምረው ፍርድ ቤቱ ይሄን ማየት አለበት ነው እና ከኤክስ ጋር የሚያገናኘው ነገር ከሌለ there is no lawful ground for arresting ይሄንን መቆጣጠር አለበት ነው አንገና ወደ ኮሌ ማይንድ ዩ ይሄ ሮል ሊኖረው ይገባል the court should have this role እና lawful ground ከሌለው lawful arrest የለም ማለት ነው አንደኛ ነገር እሱ lawful ground አለው ወይ የሚለው ሁለተኛ ነገር ደግሞ arrestus was the arrest also lawful የሚለውን ነገር ቼክ ማድረግ የለበትም ፍርድ ቤቱ the process of arrest ቼክ ማድረግ የለበትም እነዚህ ነገሮች እና if there is no lawful arrest ማለት ኤክስን አሬስት ለማድረግ lawful ground reasonable ground ከሌለው ፍርድ ቤቱ ሰውየውን ልቀቀው ማለት አለበት ተጨባጭ መረጃ እኮ የለም ኤክስ እንደፈጸመ እኮ ያሳየን ማስረጃዎቹ በቂ ማስረጃ ማስረሰከም ኤክስ እንደፈጸመ የሚያሳይ ስለዚህ ልቀቀው ማለት የለበትም ፍርድ ቤቱ the court should have this role otherwise ፍርድ ቤት ሄዳችሁ ተደምረው ጥቅሙ እሱ እንዳለው የዋስትና ጉዳይ ጥሩ ነው ዋስትና መለከት ካለባችሁ ዋስትና መብታችሁ ምናምን ይታገል ከዛ በፊት ግን በጣም እናንተ የምትፈልጉት ምንድነው አላግባብ ነው ፖሊስ ያሰረው እኔ ኮንጁር ጋር የሚያገናኝ ነገር የለም ስለዚህ አላግባብ there is an unlawful arrest ምንም ኮንጁር ጋር የሚያገናኝ የለም ፖሊስ የሰበሰበው ማስረጃ ኮንጁር ጋር የሚያገናኝ ነገር የለም ይሄን ፍርድ ቤቱ ቼክ ማድረግ አለበት ቼክ አድርጎ ከጉጂ ከታሰርኩኝ ፍርድ ቤት ሊያስለቅቀኝ ይገባል ብላችሁ ታስባላችሁ በፖሊስ ቁጥጥር ስር ካላችሁ ይሄንን ነው ከፍርድ ቤት የምትጠብቁት እናንተ but does the law say like that very quickly say article 59 አንብቡት ይሄ ነገር ከሌለው በጣም እንግዲህ ፍርድ ቤት ሄዳችሁ Article 59. So Article 1, the court before which the arrested person is brought shall decide whether such person shall be kept in custody or be released on bail. The court shall decide whether that person shall be kept in custody or be released on bail. And Article 2, where the police investigation is not completed, the investigating police officer may apply for a remand for a sufficient time to enable the investigation to be completed. A remand may be granted in writing. No remand shall be granted for more than 14 days on each occasion. Very good. So, have you got your point? I mean, is this provision compatible to your expectation? Have you got what we expected from this provision? No. Have you got what we expected from this provision? No. No, what the court can do is this. Whenever the suspect is brought to the court within 48 hours, what the court can do is what is written under Article 59. Look, that's all changing. This is what the court can do. What will the court do? First, Article 1, the court before which the arrested person is brought shall decide whether such person shall be kept in custody or be released on bail. So the first thing is, as you rightly said, the issue of bail. So the court will consider, mind you, the court will not go under Article 1, the court will consider whether that person should be kept in custody or be released on bail. It means the question of bail will be entertained. So on appearing before a court, what you can do is, the Honorable Court, let me be released on bail. This is what you can ask. Under Article 1 it says. So the court will decide whether you have to be, the court will consider. Are you entitled to be released on bail? According to the law, we will look at how bail is treated in the criminal procedure. We will see. Under what circumstances you can be denied or be released on bail. We will see that. But the point here is, the court will consider whether you are entitled to be released on bail. If you are granted bail, then you will be released. It is on bail. So you are released on bail. So whenever the process will go on, and on the trial date you have to appear in court. Bail doesn't mean that you are released forever. Many people are confused, isn't it? And you hear people being angry whenever they hear that a person is released on bail. ዋስትና ሲለቀቅ ይሄን የመሰለ ወንጀለኛ ይላል ሰው። የዋስትና ትርጉም ስለማያውቅ ነው። ይሄ ሰው እየተለቀቀ በቃ ልክ እስከ መጨረሻ የተለቀቀ ነው የሚመስለው ሰው። But that is not the concept of bail. Bail ዋስትና ማለት ስትፈለግ አይደለም። ክስ ምናምን ይቀጥላል እኮ ፍርድ ቤት ይቀርባላችሁ እኮ ከክሱ ነፃ ሆናችሁ ገና mind you don't have to be confused. So the court will consider this thing. So if you are entitled to be released on bail, then you will be released. Otherwise, you will be sent into custody. So that's what Article 1 says. And Article 2, where the police investigation is not completed, the investigating police officer may apply for a remand for a sufficient time to enable the investigation to be completed. Even ዋስትና ራሱ ከመጠየቃቸው በፊት ፖሊስ ምን ይላል? የተከበረው ፍርድ ቤት ምርመራዬን አልጨረስኩም ይላል። So that the person should be remanded. ምርመራ እስኪያደርስ ፍርድ ቤት መቆየት ማረፊያ ቤት መቆየት ነው ሪማንድ ማለት ነው. Until investigation is carried out, or until investigation is completed, you will be forced to stay under police custody. So it is what we call remand. Okay? So if under sub-article, the court has such power, but police will immediately ask that I haven't completed investigation. So let the honorable court give me additional time for investigation. Many yala masala to China. Eh, so ye Boston I legat. Boston I legat Marina Charoskumia. This is an obstacle for your release on bail. Boston I legat island police. Then indirectly mean Marina Charoskumia. So this is Marmara Charasa was not Telebacoma. So this is Yala police. But Kafis are police address. Yes, or here. You shouldn't be released on bail again. Za many that's Article 3. A remand may be granted in writing. What debate remand sit a checken. Marmarena Charaskunsi, I checken. No remand shall be granted for more than 14 days on each occasion even. Za for debate? Marmara Charaskunsi. She Asaka, Marmara with Setor. Azabana, Kazaras was another level. Police custody, you will be under police custody. Remanded on a job man. Remanded with Bali. Marmaras captures and so police Maragasas, he is remanded in Bali. Or remanded prisoner in Saratan. Kazakastan, the Polisaria Poita, Basaranga, Camara Davis, Maracavit to use the Polisaria. Basaranga to the debate about police. It took a borrow for debate when you look at it was a solution on Marina Charles. Za debate ayna ahon mi dala ndagana on each occasion ila za sent kali bakal police 15 8 ka setcha ahoንም ተይዛችሁ ጋማችሁ ተይዛችሁ ፖሊስ ታገር ከዛ ከ8 ቀን በኋላ እንደገና ይመጣል የተከበረው ፍርድ ቤት አሁንም አጨረስኩም ይላል ሊከለከል የለም የሚያስርግ የለም ፍርድ ቤቱ አሁንም አጨረስም እንደምን ማለት አይችልም because there is judicial activism. There are some very brave judges. Still, ምንድነው ያደረከው ይላል እስቲ አንተ ምርመራ መስገብን አንተ እንዴ እዚህ ድረስ መሄድ ነበር እዚህ ጋር ምን እዚህ ሳምንት ሰራ ነበር 8 ቀን ነበር የሰጠው በጣም በይቀ ነበር መጨረስ ነበር 2 ቀን የሰጠው ከዛ 2 ቀን ቆይቶ መጥቶ አሁን ማጨረስኩም ይላል ምን ያርግ ምንድነው ፍርድ ቤቱ ማድረግ የሚችለው ስልጣን አለው is there any provision which allows the court to release that person ምርመራ አጨረስኩም ይላል በየጊዜው ፖሊስ ፍርድ ቤት ነው ስልጣን የለው በህግ ነው መንቀሳቀስ የሚችለው the court can do in accordance with the law but the law says nothing. Okay, that is a very problematic position. Please, Martha. The term may applies for the formality. So the formality no. May be granted in writing. It is talking about the formality for granting remand.
So it may be granted.
Yeah, maybe good. ስለዚህ ይሄ ማለት በቃል ሊለው ይችላል ፕራክቲስ yes ያስር ቀን ሰጥቻለሁ sometimes ምን ያደርጋሉ መሰለሽ በጽሁፍ 10 ቀን ተሰጥቷል ቢሮክራት ካልሆነ ደግሞ 10 ቀን ተሰጥቷል እዛው ፍርድ ቤቱ ዳኛው የሚሰጠው ነገር ነው anyhow it is talking about formality but in practice የሚሰሩት ምንድነው እዛው 10 ቀን መመራ ሰጥቷል በስምንት ቀን ይላል ፍርድ ቤት መዝገቡ ላይ ይመዘገባል ፖሊስ ይሄዳል ፖሊስ እዛው ይጽፋል ፍርድ ቤት የሚለው ታረቀ and the point is it is about the formality and it is not about the discretionary power of the court so this is a very problematic provision please on each occasion ስለዚህ አጨረስኩም ባለ ቁጥር እንደገና አሁን እሺ 10 ቀን ሰጥቻለሁ ይለዋል አሁን ፕራክቲስ እየሰማን ያለው ነው ይናረለ እንዴ አሁን እየሰማን ያለው ነው ይሄ ስለዚህ በቃ ዳኛ ሶኑ ምን እንደምታረቁ አላውቅላችሁ እኔ ባለጀጅ እስከዛ ድረስ ግን ይሻሻል ክሪሚናል ፕሮሲጀሩ አሁን እኮ ክሪሚናል ፕሮሲጀሩ I am expecting that in this year የግድ ነው ስንት አመት ሞላ ክሪሚናል ፕሮሲጀሩ ፓርላማው ያየ ነው እናንተማ ገና ሰርቪስ ናቸው ዛሬ ስንት አመት ተማሪ ያለን ጀምሮ ክሪሚናል ፕሮሲጀሩ ፓርላማው ያየ ነው ነበር ከኛ በፊት ነው
ከ57 1961 ነው ለክሪሚናል ፕሮሲጀር ያው 1961 ግጠኛ ነኝ ከሚቀጥለው ዓመት ጀምሮ እየተባለ ነው ከ62 ጀምሮ እየተባለ ነው ሁሌ ኤንድ ክሪሚናል ፕሮሲጀር ኤቪደንስ ነው እንደዛ እየተባለ ነው አሁን ግን ተጠቃሎ እንግዲህ ሁለቱንም አንድ ላይ ክሪሚናል ፕሮሲጀር እና ኤቪደንስን የያዘ ህግ ሊወጣ ነው አሁን እንኳን ጫፍ የደረሰ ይመስለኛል ኦኬ Habeas corpus. What she read is provision about habeas corpus. But if you are not brought to the nearby court within 48 hours, you have a remedy. If you are not brought before a nearby court after arrest within 48 hours, you do have a right to habeas corpus. So, it may be a secret detention, which usually happen. You may not be detained in police custody. Police money no only. Police are behind this camera. Most of the secret detentions are. How good does that work? Yeah, wherever you are, zao nacho mama nacha. So mukulacho na tabafi David telefon. Kalau mahal telefon. Okay. Ferdibit take a look. You can ask when you are at the Ferdibit at Karlakum Barbas and Musatus. You have to apply marriage standard. That is what we call habeas corpus, and that is what Article 19 is talking about. Read sir. Yeah. Yes. What do you think that the provision that you read? Do you think that the provision that you read allows the court to do so?
Yeah.
Why did it read to us? Yes.
That first, Article 90 sub 4 says, all persons have an immediate right to receive the court for order their release, where the arresting police officer or the law enforcement to re-examine before a court continues to provide evidence for their arrest. I think the 28 now required. But then it says, where the
No, that is the point. That's a very good point that you raised. I mean, they have the right to request the court for their physical release, it says.
Where the interest of justice requires, the court may order the arrested person to remain in custody, or when requested, remand him for a time strictly required to carry out the necessary investigation. So it says, the court may approve the remand or may reject it. So it's up on the court's discretion.
But it doesn't say to release. That's a very big problem. The provision that you read to us.
What happens if the court rejects the remand, the request for remand?
I mean, the court will give reasonable time. And if there is no need of remand, then it means that an institution, a criminal charge should be immediately instituted. Remand አያስፈልግም ምርመራን እኮ ጨርሰሃል ተጨማሪ ጊዜ ካለ አይ ተጨማሪ ጊዜ ያስፈልጋል ምርመራን ጨርሰሃል እኮ ስለዚህ ቀጥል ምርመራን ከጨረስ ቀጥል ነው ግን በተደጋጋሚ እየጠየቀ ፍርድ ቤት ተጨማሪ ማስረጃ ማግኘት ስላልቻለ አይ አሁንም ላምጣ then it means that ሰውዬን ለጥፋተኛ የሚያስብል ማስረጃ ሲጀምር የለም ማለት ነው
ስለዚህ ሪማንድ ተከለከለ ማለት ነው የሰውዬ መውጣት ፕሮባቢሊቲ ያለው ላይ ቁጭ ላይ ሆኖ ጉዳዩን መከታተል ማለት
but the provision is not explicit that provision is not explicit in allowing the court by justification ካልሆነ አሁን ቅድም ያነሳሽው every person has the right to request the release of his physical person ካለ አላግባብ ስለታሰርኩኝ የመለቀቅ ማንኛውም ሰው አላግባብ የተያዘ ሰው የመለቀቅ እንዲለቀቅ የመጠየቅ መብት አለው ካለ ሲጀምር ፍርድ ቤቱ ኢንዳይሬክትሊ የመልቀቅ መብት ያጎናጸፈው ነው ማለት ነው the constitution and that ground people have the right to ask the court to scrutinize the grounds of their arrest but it is not explicitly provided that the court should release that person if there is no justifiable ground of arrest የሚል ነገር የለም and there is a very poor practice of applying constitutional provisions constitutional provision interpret ማድረግ ይጠይቃል the provisions that you raised ያን interpret የማድረግ ስልጣን የሰጠው ማን ነው is for the House of Federation ግን ጁዲሻሪው አይ ከዚህ አንፃር ኢንተርፕሪቴሽን ስለሚፈልግ ወደ ሃውስ ኦፍ ፌዴሬሽን ኢንተርፕሪት ይደረግልን እስከዛሬ ማተባለ then also other international human rights instruments ኢትዮጵያ ራቲፋይ ያደረገቻቸው international instruments do not allow unlawful arresting of a person. Ethiopia states party to a number of international human rights instruments. Courts do not apply that. Courts prefer to apply provision, criminal procedure doesn't even do this. Generally, government to interpret and there is no such practice. There is no such. Please get it. So you ዋስትና ይለቀቅ አለበዛ ዋስትና ማይስለቅ ኮኔ ይታሰር ከዛ በኋላ ሰባት ክፍል ጋር ነው ስመጡ ፖሊስ እንደውም ተጨማሪ መበረክ ይሰጠኝ ብሎ መጠየቅ ይችላል ይላል። ሰባት ክፍል ስሪ ጋር ስትመጡ ፍርድ ቤቱ እስከ 14 ቀን ኦን ኢች ኦኬዥን ይፈቅድለታል ይላል። በቃ unlawful ground unlawful arresቱን ይመረምራል። ከዛ unlawful ከሆነ ይለቀዋል እና የሚል ነገር የለም unless you justify your argument basing the constitutional provisions like Martha raised. ኮንስቲቱሽናል ፕሮቪዥኖችን የሁማን ራይቶችን አንስታችሁ ራይት ቱ ሊበርቲ ማንሳት ትችላላችሁ። አርቲክል 19 ላይ በነፃ የመለቀቅ አንሎፉል አሬስት ሲኖር ፊዚካል ሪሊዛቸውን ሊለቀቁ የመጠየቅ መብት አላቸው ምናምን የሚለውን ትሬስ አድርጋችሁ unless you argue that way there is no clear explicit provision የለም። የመሰለውን ግን በ59 መሰረት ይላል።
በ59 መሰረት ደግሞ ቤል ስላለ ቤል የሚያስፈልግ ከሆነ ከመሰለው
በቤል የሚያስለቅቅ ከሆነ በቤል ይለቀቃል። ጥሩ ነው። አንሎፉል አሬስት ለምን አንተ ወደ ቤል ትሄዳለህ? አንሎፉል አሬስት እያለ ቤል እኮ ፍሪ ሰፖዝ የሚያደርገው አዎ ትክክል ነው። የተያዝክበት ግራውንድ አለ there is lawful ground እያለ ነው። lawful ground ስላለ በዋስትና ይለቀቃል። ግን ሲጀምር መያዛቸው ራሱ ትክክል አይደለም። መያዝ አልነበረብኝም እኔ እኮ በስሙ ሁሉ ተሳስቶ ይመስለኛል። እንደውም አንድ ጊዜ ፖሊስ አስሮ አቅርብ ተብሎ ታዘው በፍርድ ቤት የት አካባቢ ነው ሄዶ አይ መልካቸው ይመሳሰልብኛል መያዝ አልቻልኩም ብሎ ተመልሶ በጣም ይመሳሰልብኛል የት አካባቢ እንደሆነ አላውቅም። እንደዚህ አይነት ስለዚህ አይ በስም ተሳስቶ ነው እርግጠኛ ነኝ ፖሊስ ወይ በመልክ ተሳስቶ ነው እንዴ ያረደውም እኮ የታሰርኩት እና ዋስትና እንደውም አትጨነቁ ዋስትና እንዴ ሲጀምር ነው የሰራው በተሳትፎ አልነበርኩም። ጅማ ነው እኮ የሚለው አሬስት ዋራንቱ እኔ እኮ ጅማ አልነበርኩም። በዛ ሰዓት እኮ አዲስ አበባ ነበርኩ ወይም ሌላ ሀገር ነበርኩ እንዴ አልነበርኩም እኔ አይደለሁም በፍጹም። ስለዚህ ፍርድ ቤቱ አይ እውነትም ይሄ ነገር በመርምሮ ወዘር ሎፉል አሬስት እና የሚለውን ማየት አይችልም ነው አርቲክል 59 ላይ ማየት አይችልም። በቃ ፍርድ ቤቱ ማየት የሚችለው በአርቲክል 59 መሰረት ዋስትናን ያያል። ኦኬ ፖሊስ ምርመራን ያጨረስኩት ሲል ስንት ቀን ይሰጠ ምናምን ነገር የሚለውን ያያል። ከዛ በኋላ ይሄን ከዚህ ውጪ ምርመራ ከተጨረሰ በነገራችን ላይ በዋስትና ራሱ ተለቀቁ ፕራክቲስ ምርመራን ያጨረስኩት ማለት ከፖሊስ ጋር በቃ ከዛ ምርመራን ጨረስኩ ሲል ነው የዋስትና ጥያቄ ይታያል። ሲጠይቀው ምርመራን ያጨረስኩት ሲል ያይና መዝገቡን ያያል። ከዛ በኋላ እሱንም ይሰማዋል። ስንት ቀን ይበቃኛል 10 ቀን ይላል። አይ ይሄን ነገሮች አድርጋለሁ መዝገቡን አይቻለሁ ይጠየቃል። ፖሊስ መዝገብ ትጠይቃላችሁ። ዳኛው ናችሁ ሲሰሩ ፖሊስ መዝገብ ይመጣል ይተላል ታያላችሁ። የሄደውን ስቴት ታያላችሁ። አይ ስንት ቀን ይጠየቁ 12 ቀን አይ 8 ቀን ይበቃል ታላላችሁ። ከዛ ውጪ ኢንቨስቲጌሽኑን እኮ ጨርሰሃል። ስለዚህ ክስ መስረት ነው ትስኖታለህ። ኮርት ደዘን አፍሰጭ ቆይ ምን ይሻላል? እስቲ በደንብ አንብቡና ኦኬ ጀስት ኤክስፕሎር